All right, folks. National War Powers Commission report. The War Powers Resolution of 1973. Now, this is a crucial issue, folks. Who has the power to make war? Attempted to resolve the fundamental constitutional questions that have been debated for almost 2 centuries, but it has failed to do so. The War Powers Resolution purports to formalize a role for Congress in making the decision whether to go to war. While it seeks to limit presidential power, the resolution, either because of drafting error or political miscalculation, arguably invites presidents to wage any military campaign they wish for up to 90 days. Once a conflict begins, however, the president is required under the resolution to terminate it within 90 days if Congress has not authorized it. See, folks, that's a big problem. Can't amend the Constitution through statute. But even more than that, Congress has to act affirmatively. But let me go on. The War Powers Resolution has been widely criticized, even by its original sponsors. For example, even ardent advocates of congressional power recognize that Section 2C of the resolution too narrowly defines the president's war powers, and many agree it has been regularly breached. Section 2C says the president may exercise his powers as commander-in-chief, quote, only pursuant to 1, a declaration of war, 2, specific statutory authorization, or 3, a national emergency created by an attack upon the United States, unquote. Since the enactment of that resolution, presidents have sent troops into conflict on several occasions when none of these circumstances were present. Grenada, Yugoslavia, Haiti. 3 examples. Constitutional scholars generally agree that Section 5C of the resolution is unconstitutional in light of the Supreme Court's later decision in INS versus Chadha in 1983. Now, Section 5 provides that Congress may compel the President to remove troops, otherwise lawfully committed to the battlefield, merely by passing a concurrent resolution. But in Chadha, the Supreme Court struck down the long-standing congressional practice of using one-house legislative vetoes to invalidate In other words, what the Supreme Court is saying, you can't just pass resolutions. You have to pass laws. And in order to pass a law, a president has to actually sign it. That's how we make legislation. So you can't legislate with a resolution by the House or a resolution by the Senate or a joint resolution. Now that makes sense, right? We don't want Congress passing laws when they're not passing laws. Many other aspects of the War Powers Resolution provoke criticism. Section 3 requires the President to consult with Congress before enduring any armed conflict. But it doesn't say with whom he's supposed to consult in Congress. All 535 members? Who? What? In practice, the statute generally has ensured some form of notification, but not always consultation. As a 2007 Congressional Research Service study of the 1973 War Powers Resolution concluded, quote, there's been very little consultation with Congress under the resolution, when consultation is defined to mean seeking advice prior to a decision to introduce troops. In other words, they'll send a letter and tell Congress, and by the way, we sent troops 3 days ago, so we've informed you, but that's as far as we're going to go with consultations. Section 4 of the statute contains detailed reporting requirements compelling the President to provide Congress with information regarding all conflicts which the country's military engages. Experts told the Commission that the general ongoing reporting requirements in Section 4C have devolved into tedious paperwork obligations that are relegated to lower-level executive personnel. The reports produced, they add, are stripped of much content in the interest of preserving secrecy as to make them hardly useful. Yes, because we know Congress never leaks military secrets, do they? This is also a problem with giving advance notice to so many members of Congress, or even a handful. They leak. So there are issues here that need to be thought about. Well, hey, you got to consult, and Congress has to... Wait a minute. Where, what, how, and when? The 1973 resolution's specific reporting requirements in Section 4A have come under especially heavy criticism. Reports filed under Section 4A1 serve to trigger the resolution's enforcement mechanisms in Section 5. And that provides that if Congress has not approved a new military campaign within 60 to 90 days, the President must halt the campaign. Not only does this allow Congress to halt a military campaign by inaction, a concept which many have criticized, no president has ever filed a report pursuant to Section 4A1. And the reason's simple. They believe it's unconstitutional, that Congress does not have the power to make battlefield decisions about the length and the purpose and the commitment of the troops. And I'm going to go on when we come back, and I'm going to make some points where I think if a president were rational and would consult with Congress a little bit more, this wouldn't even be an issue. We'll be right back. See, Section 5 of the War Powers Resolution is the worst of the sections. And I want you to keep in mind why guys like Kucinich keep waving this around. Because they are radical leftists who don't believe in defending this country. Now, Professor Robert Turner wrote a fairly substantive paper for the Federalist Society a few years back. And on Section 5, follow me on this, because you're going to now become conversant in this, whereas all these other people, hey, the war pay, what about this? You're going to know what you're talking about. Section 5 of the War Powers Resolution contains two of its most controversial features. I just want to underscore this. Section 5B provides that if Congress does not authorize the President to continue the deployment, that is, sending forces into hostilities or into a situation where imminent involvement in hostilities is clearly indicated by the circumstances, that 60-day clock begins running, the President must withdraw the forces. Now, he's allowed to keep them there another 30 days, if necessary for their own safety. This is sometimes referred to as the silent veto by Congress, and it allows Congress to terminate an operation without having to take a formal stance on its merits. Others have noted that if the United States gets into a quarrel with bad actors abroad, which the President, either the House or Senate, think is in the national interest, but about which the other branch of Congress is unable to make up its mind, the law awards the victory to the enemy. Few modern supporters of the resolution defend this provision. And yet those of you running, War Powers Act, this is the problem with this provision. You could literally have enough liberal senators block the House, block the President, force the withdrawal of troops in cases where we literally need our troops doing what they're doing. Section 5C is even more clearly objectionable on constitutional grounds, as it authorizes Congress to order the withdrawal of U.S. forces from hostilities by concurrent resolution at any time. That is a resolution of both houses. A concurrent resolution requires the approval of the House and the Senate, but not the President. And the practice of attempting to legislate by resolution was struck down in 1983 by that decision I told you in the Supreme Court, INS versus Chadha. Now, this is important beyond the War Powers Act. This is important beyond the War Powers Act. Imagine we have a Republican president and a Democrat Congress, and for many, many decades, that's the sort of arrangement there was. You'd have them run in circles around the president and not legislating through resolutions. So we'd be talking about changing the power of Congress. Just remember what happened in the Obamacare matter. If they get a supermajority, and let's say there's a Republican president even, and they have enough votes to override a presidential veto, which is how we got the War Powers Act in the first place, over the objection of the Nixon veto. Imagine what they could do legislatively with their concurrent resolutions. It's a terrible, terrible precedent, this Section 5 of the War Powers Act, particularly 5C, because it changes the Constitution. It changes how Congress legislates. And in this case, it can actually pull troops off the battlefield with one House refusing to act. Well, declaration of war, we have to have a declaration of war. No, we don't always have to have a declaration of war. But here's the problem. Presidents have tried to avoid this confrontation. Historically, they have attempted to avoid this confrontation. The courts refuse to get involved in it, and that's correct, because the judges don't know any better, and they want this resolved politically, that is, between the branches. But what presidents try to do is literally pull in the leaders of the various parties, the two houses, the relevant committees, and talk to them, and send their Secretary of State and Secretary of Defense or whomever to explain to them exactly what they're doing and why they're doing it. And they're worried about leaks all the time because Congress leaks like a sieve, so they don't want our armed men and women on the battlefield harmed because some jerk congressman or senator leaks to the New York Slimes or Washington Compost, which are utterly irresponsible. But at some point, they need to consult with Congress. Not the UN, Congress. And they should do that for political and policy reasons and to avoid a constitutional confrontation. This president doesn't think he has to consult with anybody he disagrees with or who might disagree with him. Therein lies the problem. Therein lies the problem. What we're doing in Libya, in my humble opinion, is nuts. And I have to laugh when I'm in the car running errands and so forth during the day and I'm listening to some of these hosts. You go back and you listen if they post their comments from 2-3 weeks ago, what they were saying. Democracy Project, we got to get in there, no-fly zone. No-fly zone? What did I tell you, Mr. Producer? No-fly zone. Don't they have flies in Libya? What's this no-fly zone stuff? Kill Gaddafi and get the hell out of there. Well, that's Mark's doctrine, the Levin doctrine. But the reason why there aren't consultations with Congress, or enough, frankly, is because this president is aloof. He's quasi-despotic in the way he thinks and acts. He doesn't think he needs to involve people he doesn't agree with. We've seen that throughout his reign. Yes, I said reign. And he's an ideologue, a left-wing ideologue. The problem is he can't even explain what the hell we're doing in Libya. So what he has done, as a caller said yesterday, correct, he's left all his options open. Whatever happens in Libya, he'll now be able to explain after the fact. Same with Obamacare, by the way. Whatever happens with Obamacare, he didn't write the bill. Pelosi and Reid did. Or their flunkies did, anyway. Well, what we had meant to do, he'll talk about grandiose ideas for the far-off future, what was intended, how it was supposed to work, but he couldn't help it if the Republicans screwed up, or this conservative nut on the court did this, or some bureaucrat did that. The man always has an out, or thinks he does. Same with Libya. Whatever happens in Libya, he intends to come out perfectly fine. The American people want to rally behind a president when there are battles going on. I look at it this way. We are spending resources in Libya. Already $1 billion, maybe more. Those are resources that are needed in Afghanistan. What the hell are we doing? I'm really serious about this. And I'm considered somewhat of a hawk. I don't know what the hell we're doing. And neither does he. Neither does anybody. Everybody's sitting breathlessly. Hillary Rotten Clinton, her thyness. Oh, she's going to make a statement about an agreement with NATO on what we're going to do in Libya. Who cares? Shouldn't that agreement have been made before you begin military action against a country? How weird is this? What they're trying to do is save face now. They can get some NATO involvement or whatever. We can pull out. They can say our job is done. Victory can be declared, and off we go. Back to destroying America from within. I've come full circle. Those of you who support the War Powers Act are supporting fundamentally changing the way Congress works and empowering the left in one House of Congress to pull our troops off the battlefield in the middle of a war. So don't be so quick to embrace it. No president, Republican or Democrat, has agreed to this. None. None of them have agreed that this statute trumps the Constitution or that one House of Congress, by withholding its support for a resolution, has the power to pull armed forces off the battlefield. Now, I will tell you this about the Constitutional Convention, even though it's a little muddy on this point. One thing that was clear was they did not want to give war-making power, war-making decisions to Congress, because they knew how crazy that would be. Endless debates, factional obstruction, so forth and so on. So a president can avoid this kind of constitutional confrontation, and we didn't have a War Powers Act until 1973. So are we saying that without the War Powers Act, that every time a president went to war and there wasn't a declaration of war, that was an impeachable offense? Because if so, I dare say about 25 of our presidents would have been impeached. So that doesn't make any sense, does it? No, it doesn't make any sense at all. Congress can defund a department, a program, anything, pretty much. If they can get it done with a supermajority and overcome a presidential veto, they've got what they want. All right, I hope I've clarified things a little bit anyway. If you want to read more about it, go to my social sites. I've linked to these two sources, and there are many, many more, but these are two very interesting and scholarly discussions.